The term geographical indications could be used for A. Agricultural goods, B. Natural goods, C. Manufactured goods, D. All the above. The answer is D. All the above. While trademarks dominate the syllabus, GI questions in Paper 1 jumped from just 1 in 2023 to around 15 in 2025. The primary legislation is the Geographical Indications of Goods, Registration and Protection Act, 1999, Act No. 48 of 1999. It received presidential assent on December 30, 1999. There is a 4-year gap before it took effect. The act came into force on September 15, 2003, the same day as the Trademarks Act, 1999. The operational framework is set by the GI Rules 2002. Under a November 2025 amendment, the entire fee schedule was replaced, bringing the application fee for a single class down from 5,000 rupees to 1,000. Administration of the Act is handled by the Controller General of Patents, Designs, and Trademarks, who is ex officio the Registrar of Geographical Indications under Section 3. The Geographical Indications Registry is located in Chennai. Note the distinction. The Trademarks Registry is headquartered in Mumbai, while the GI Registry is anchored in Chennai. Mastering this subject requires moving past trademark assumptions and focusing on these distinct administrative structures. The statutory mandate comes from Articles 22 through 24 of the 1994 TRIPS Agreement. Article 22 provides general protection, while Article 23 requires additional, higher protection, specifically for wines and spirits. India expanded this scope. Under Section 22, subsection 2, the central government has the power to notify any goods for that higher level of protection, not just wines and spirits. This defensive legislation was triggered by international disputes over basmati rice, turmeric, and neem. India needed a legal mechanism to protect products whose reputation is tied to Indian soil and traditional skill. There is a specific legal distinction to keep in mind. GIs do not directly protect traditional knowledge or cultural expressions. Instead, they contribute to their preservation by rewarding the communities that maintain traditional methods. Because the GI Act serves as a shield for regional heritage, its rules are more rigid than standard corporate intellectual property laws. Section 2, subsection 1, Clause E, defines a geographical indication through 5 specific elements. First, it is an indication, a name or figurative representation. It doesn't require a geographic place name. Basmati qualifies because it is a name related to a specific area. Second, it identifies goods. This includes agricultural, natural, and manufactured goods, as well as handicrafts and foodstuff. It never applies to services. This includes agricultural goods, such as Darjeeling tea, natural goods, like Makrana marble, and foodstuff, like Bikaneri bhujia. The third element requires that the goods originate in a definite territory, region, or locality. Fourth, a given quality or reputation of those goods must be essentially attributable to that geographical origin, a result of natural and human factors. Fifth is the rule for manufactured goods. At least one of the 3 activities, production, processing, or preparation, must occur within that specific territory. A GI tag protects the regional link and the name, but not the production technique itself. Anyone can copy the method. They just cannot sell the resulting product under the protected GI name.
A GI is a legally certified combination of geography, skill, and specific nomenclature. Section 2, subsection 1, Clause K, defines producer with 3 verbs. For agricultural goods, you produce. For natural goods, you exploit. For handicrafts, you make or manufacture. Crucially, the definition includes anyone who trades or deals. A trader is legally a producer. A merchant selling Nagpur oranges fits this definition, as does the artisan making Kolhapuri chapels. There are 3 distinct players in the system. Player 1 is the applicant. Under Section 11, only a representative association of persons or producers or a legally established organization can apply. An individual company acting alone cannot. Player 2 is the registered proprietor, the association or organization once it is entered into the register. Player 3 is the authorized user, a producer of the goods who registers with the GI Registry to use a specific GI. The law divides rights between them. The exclusive right to use the GI belongs to the authorized user, but both the proprietor and the authorized user have the right to sue for infringement.
This structure prevents any single entity from monopolizing what is intended to be a community asset. A GI differs significantly from trademarks. A trademark is assignable private property. A GI is community property. Section 24 prohibits assigning or licensing a GI. The only exception is the death of an authorized user, where rights devolve to their successor. Darjeeling tea serves as a unique example here, as it is protected both as a GI and as a certification mark under the Trademarks Act. These rights are managed through the Register of Geographical Indications in Chennai. Section 7 organizes the register into two parts. Part A contains the particulars of the geographical indications. Part B contains the authorized users. Removing a user requires Form GI 5D. This dual register system separates the community right from the individual beneficiaries. Section 8 requires that every registration specify both the particular goods and a definite geographic area. Goods are classified using the 4th schedule of the GI rules, which contains 34 classes. This is fewer than the 45 classes used for trademarks. This difference is because the GI Act excludes services entirely. Under Section 8, subsection 4, any dispute regarding the class of goods or the definite area is determined by the registrar. The statute specifies that the registrar's decision on these boundary and classification questions is final. To lock in what we've learned, we will end this session with a rapid-fire review of the most critical statutory facts for the exam. On what date did the GI Act come into force? September 15, 2003. In which city is the GI Registry located? Chennai. Who acts as the registrar of GIs? The Controller General of Patents, Designs, and Trademarks. What is recorded in Part B of the register? Particulars of authorized users. Is licensing a GI permitted? No. Section 24 prohibits it. India's first GI registration, Darjeeling tea. Classes in the 4th schedule, 34. Does the Act cover services? No. These statutory dates and definitions form the mechanical core of the subject. In the next lecture, we build on this foundation by examining the grounds for refusal in sections 9 and 10.